All right, good morning, civics class. I hope everybody's doing well. Uh, Today, I'm going to share with you um, some notes on the history of law. So this unit we're on deals with law, justice, um, and the court system. And we want to start out early here talking about the history of law. How did law in America develop? So we're going to go through kind of a timeline of uh, law throughout the world, and then we'll basically finish up talking specifically about the American legal system and how that uh, body of law developed. So let's get started. All right, so you might recall from world history the Code of Hammurabi. So this is the earliest known set of laws. Um, One of the interesting things about Hammurabi's code was that not only was it the first or the earliest written code of laws, but it also had very tough punishments, punishments that we would consider um, harsh by today's standards. For example, if you steal something, you know what would happen? You would get your hand cut off. So that would probably be seen as cruel and unusual today, but back then the idea was for the punishments to fit the crimes almost exactly. You put out an eye, you have your eye put out. Um, you burn down a house, then fire would be involved in your punishment. So that's one of the examples of how we look at punishment and how you punish people who break the law. So we get a lot of those ideas from the Code of Hammurabi. Another thing to think about is why. Why is it important to write the law down? Uh, Probably because you want everyone to know what it is so that people can't claim that they don't know what the law is. So it needs to be written down for everyone to see. So there's no question uh, about what the law says. All right, moving forward in time, you've got the 10 Commandments. And for this class, we don't want to look at the 10 Commandments from a religious point of view, but from a legal point of view. These were 10 laws um, that we look at today as kind of a moral standard of behavior. Things like not stealing, not lying, not murdering. Um, the reason why some stores are closed on Sundays, like Chick-fil-A, because of the law about keeping holy the Lord's Day, or keeping the Sabbath holy. So laws are sometimes based on religious or moral codes. There are some overlap there. So our laws against adultery or against murder, those can be reflected uh, in the 10 Commandments. All right, Draconian Law. So this comes from Greek legal code. And basically, anytime you hear the word draconian, it's dealing with the idea of harsh punishments. And punishments, of course, what is the purpose of harsh punishments? Well, it's basically deterrence. So if you know that if you do something, you're going to get punished harshly, that's going to deter you or almost scare you into not um, committing that act or not taking that action. So if you relate it back to school, right? Um, if you know that a teacher is going to take your phone from you, you might consider that a harsh punishment. So you will be less likely to use your phone in class. If you know that if you skip class so many times, you might get ISS, or you might get um, OSS, out of school, for 3 days or 5 days. You might consider that harsh enough that deters you from doing those things. So draconian deals with deterrence, deals with the harshness of the punishments. All right, during the Byzantine Empire, Emperor Justinian decided to create a collection of written laws and also legal interpretations. So by this time, judges were commonplace, and the idea of creating a body of civil law where you could go and see what judges had to say about certain situations. That'll be important when we talk about common law and precedent and how important that is to today's judges. But that's something we can trace back to the Byzantine Emperor Justinian. All right, so now we start getting into British law, which very much influences our American system of law. So like I was saying, English common law is taking that collection of judicial decisions, judicial opinions, interpretations, codifying them, collecting them, so that judges can go read those decisions and use that as kind of a basis to help them make decisions in the present. So if you look at the diagram there, you see past cases. If they're similar to the current case, you can use those to help you as a judge make your decision. All right, Magna Carta. Now, when we talked about the Magna Carta, we talked about this in terms of limiting the king's power. And that is part of the law because the law is designed not only to protect people from each other, but the law can be used to protect the people from the government. So we do want to make sure we note the Magna Carta once again here. Very important. 1215 back in England, King John was forced to sign a document protecting the rights of his people. So this establishes the idea of the rule of law and limited government, that yes, you might have a leader like a king, but there's a body of law that supersedes that individual's power. Okay, so the king, couldn't take away the right to a jury trial. That was one of the rights that were mentioned in the Magna Carta. So those ideas, of course, are used today in American law. All right, moving into America, we know that Native Americans had their own civilization in America first, and they had their own systems of law and government. Even though you might think of Native Americans as having, isolated tribes to themselves, they actually did have more of a network of government and civilization. They traded with each other. They went to war with each other. They had to make peace with each other. So the Iroquois Confederation was a system of native tribes that agreed to work together. They would meet together to make decisions, just like any government would. And part of that would be to create laws that would apply to the Native American tribes themselves. All right, colonial law. So this is once the English and other Europeans started to settle in what we call America. They had to create their own systems of government because they were thousands of miles from Europe. So they knew that in order to survive, they would have to have someone in charge, a set of rules. So in Jamestown, Virginia, they used a system of representative government that we call the Virginia House of Burgesses, where they would elect representatives to make decisions and make laws for the colony. Further up north in Plymouth, the Pilgrims, while they were on the Mayflower ship, signed a document called the Mayflower Compact, which basically said that they all agreed that they would abide by a system of government that they would create in order to do what's best for the community. And basically what this developed was a system of direct democracy, where all of the basically the men and women would gather in these town meetings, and they would meet and they would make decisions collectively, usually at a church or a town hall or something like that. But it set up this idea of getting the community together in a caucus style of system. Remember, we talked about caucuses right before the break when we were talking about the election. So they would gather usually at the church, and you might have someone in charge of the meeting, but it was a very collective body, and they would all work together to make laws and decisions for the community. All right, around the same time, the colonial period, over in Europe in particular, there was the Enlightenment taking place. And remember, the Enlightenment was basically a series of philosophers and writers who just thought about new ways of looking at the world, looking at government, looking at religion, looking at power, and putting those ideas onto paper and creating these theories. So people like John Locke, Montesquieu, Rousseau, Voltaire, they were very influential when it came to developing our own American system of law, because our founding fathers, people like Thomas Jefferson and James Madison, Benjamin Franklin, were very familiar with the works of these Enlightenment thinkers. And they used a lot of those ideas as they were creating our own American style of government and law. Government and law go hand in hand. I know I've mentioned government several times, but government and law, they go together, because who makes the law? It's the government. So you want to make sure that the government is kept in check. It has rules and procedures that they have to follow, because you don't want laws to be unfair, unjust to the people. So you can't really talk about law without going back and talking about the people that make the law, and that's the government. And part of that is understanding that when the government creates laws, those laws have to reflect the idea that they have to respect our rights. We're born with certain natural rights, as John Locke said: life, liberty, the right to property. And the laws that the government creates and the actions the government takes should never eliminate those rights. All right, then we get into some of our early founding documents. The Declaration of Independence, of course, reflected a lot of John Locke's ideas about unalienable or natural rights, and the fact that governments are created to protect those rights, so that should be reflected in the law. Our first attempt at governing ourselves around the time we were fighting the British in the Revolution was the Articles of Confederation. And this was basically a lawmaking body called a Congress who could create some laws, but really lacked a lot of power to enforce those laws and to get the newly formed states to comply or follow the laws. So if you can't enforce your laws, laws are pretty pointless. So that's something to keep in mind. It's one thing to make laws, it's another thing to enforce those laws and to get people to comply. And that's one of the problems the Articles of Confederation had. So eventually, after Shays' Rebellion, just a little review there. Remember, after Shays' Rebellion, a constitutional convention was called in Philadelphia in 1787 to revise the Articles of Confederation, but they went further than that and basically created a whole new American system of government, one with 3 branches: a legislative branch that would make the law, an executive branch that would enforce the law, and a judicial branch that would interpret the law. All right. So once that Constitution was created, we know there was this ratification period where the Federalists and Anti-Federalists argued over whether or not they gave the new government too much power. And the Anti-Federalists in particular were worried that without a Bill of Rights, without some sort of a list of freedoms and rights that the people had, the newly formed government would become tyrannical and infringe upon those rights. So eventually the Federalists agreed, and soon after the ratification of the Constitution, around 1791, the Bill of Rights was ratified, which protects a lot of things like freedom of speech, your due process rights to make sure you have a fair trial, and other various rights that we've mentioned previously. Now, when it comes to the law, once again, the idea is that laws that are created, there has to be rules. You can't just make any law. So laws have to abide by the Constitution. Otherwise, they're unconstitutional, right? Which is one of the roles of the Supreme Court, to strike down unconstitutional laws. Well, early on, the Bill of Rights, remember, was only established to protect us from the federal government. So by the mid-1800s, after the Civil War, we started to realize that people needed to be protected from their own state and local governments, not just the federal government. So the 14th Amendment, remember, was created to protect the newly freed slaves, African Americans, grant them citizenship, grant them equality under the law, make sure they have due process rights, really to protect them from those state governments, because there was a large population of former slaves that would be living in the South, and as we now know, had to deal with a lot of horrible things. So the 14th Amendment, even though it wasn't properly enforced by the courts, was designed to try and protect African Americans from the governments in those states in particular, to try and make sure that they were treated fairly and equally. So the 14th Amendment, that's one of the things we started with in this week's unit. So I want to kind of finish with it here. 14th Amendment, very important. The courts have used the 14th Amendment to make sure that state governments respect the rights of all citizens, just like we expect the national government to do the same. Okay, if you've got any questions about the law, make sure you contact me. And I hope you guys have a good week. Close to spring break. Hang in there.